First of all, I want to thank you for everyone to joining our webinar series today. It's a happy Veterans Day, and we want to thank everyone who served and those who are still serving in the military. Today, I'm going to talk to you about the overview of IP protection outside the United States, with a special focus on China. And I'm going to let you, talk to you about, after filing in the US, what's going to happen, what will happen, how we're going to do it, what's the best way to approach this. And so now that you started a business in the US, the next thing you want to consider is IP protection outside the US. And you should consider that pretty soon and pretty quickly, because there are certain instances where you need to be wary or aware of the timeline that you have to worry about. And just so everyone knows, IP protection is territorial. What that means is you're going to need to file in each country or jurisdiction where you actually want IP protection. For a business that deals with products, oftentimes you're going to have something got to do with a foreign connection. For example, your products or components may be made in China, and sometimes your products are sold overseas, although sometimes they're done without your authorization. So foreign protection is important in that sense. So I'll be first discussing four main types of IP protection outside the United States. You have the functional utility patent, you have design patent, ornamental for the ornamental shape of the design. You have trademarks such as a brand, and then I'm going to briefly touch on copyright. Before we go into details of what, where, when, and how, I want to give you a little background of the information regarding IP foreign protection. US is a member to 5 international treaties and agreements related to IP. There are the Patent Cooperation Treaty, what we call PCT, and is applicable for utility patent. You have Paris Convention for utility and design patents and trademarks, the Hague Agreement for design patent, the Madrid Protocol for trademark, and the Berne Convention for copyright. All of these are administered by the World Intellectual Property Organization, which we call WIPO. Note that these treaties and agreements only facilitate securing and to some extent maintaining these foreign protection, but there's no such thing as an international patent or international trademark that affords protection for the entire world. So when do we need to seek IP protection? There are different ways and different timeline for patent, trademark, and copyright. For patent, typically is you want to file it before the statutory deadline. And most foreign countries have an absolute novelty requirement so that you should file it before any public disclosure. However, in the US, if a US case already filed, then you can claim priority to the earlier US filing under the Paris Convention. If it is a utility patent, you have 12 months to claim priority to the US filing. And for design patent, you have 6 months to claim priority to the US filing. What it means by claiming priority is that the effective filing date of your foreign case is essentially will be the earlier US filing date. So for trademark, you file foreign protection at any time. There's no deadline and can be no deadline at all. Similar to the design patent, there is a priority claim under the Paris Convention for a 6 months priority claim. Although there's no time limit on when to file for foreign country for trademark, it is very important to file sooner than later, especially in first to file countries. First to file countries such as China, the first one who filed a trademark application has priority rights. In comparison to first to use countries such as the United States, the first one who actually used the mark has priority rights. Some of the first to file countries, which we will discuss a little bit more, includes China, and I'll tell you a little more about the problem that may arise in terms of first to file country. But other first to file countries include Japan, Europe, Mexico, South Korea, and many other European countries itself, and many South American countries. As for copyright, you can foreign file a copyright at any time, similar to a trademark. One thing to point out is that under the Berne Convention for copyright rights are automatic, does not require any formalities such as registration. Copyright created in a country is afforded the minimum rights in other member countries under the Berne Convention, such as protection for at least 50 years after the author's death for most work. Most of the countries, 179 out of 105 in the world, are members of the Berne Convention. Given this, the focus of the rest of this webinar will be on patents and trademarks. There are a couple of options in foreign filing a patent trademark. It's direct versus indirect. On the left side, I show that the direct filing is basically filing directly in each individual country where you want protection, in each specific country. And the indirect route is using the WIPO agreements and filing it through WIPO, and WIPO will then send it out to various different member countries. We'll be talking about indirect filings for the rest of the webinar regarding for utility, design, and trademarks. For utility patent, next slide, please. For utility patent, the PCT international patent application can be filed. The PCT covers 153 countries, those that are shown in blue on the right-hand side of the map. There are quite a lot of countries that are covered. After filing the PCT application, within 30 months from the earliest priority date, you'll need to enter national phase in the select country to continue with the application process, which is then similar to what you do in a direct filing. Each designated country then examines the application and then decides under its own rule whether to grant a utility patent. The PCT only facilitates the process by carrying out the search and written opinion on patentability, which is then available to the designated countries. But the designated countries are not bound by the search and the written opinion, and will often independently conduct their own searches in deciding whether to grant or not grant a particular patent. For indirect filing of a design patent, you can file a Hague, what we call a Hague International Design Application. It covers 91 countries, those countries that are shown in yellow highlight on the graph on the right. So it covers less countries. The US only joined the Hague International Agreement only 5 years ago, versus the PCT, which the US has been a member of for over 40 years. So this is a relatively new method for US applicants to seek international design protection. The only difference is once you file a Hague design application, as long as it meets the WIPO formalities, an international registration certificate is issued. Each country then examines the application and decides whether to grant protection. The Hague International Design Registration is only effective in those designated countries that have agreed to grant protection. Again, this is based on their own country's own rules and regulations, whether they will grant your design. Compared to PCT filing, the select countries must be done upon filing of the Hague design application. In the PCT case, you have until 30 months after the priority date to selectively choose which country to pursue the utility patent application. As for indirect filing for foreign trademarks, you would file a Madrid Protocol International Trademark application, and it covers 121 countries as shown in blue on the map. The dark blue essentially shows the European Union, but they're all included as a member of the Madrid Protocol. US has been a member of the Madrid Protocol since about 2003. So we've had this resource for quite a few years, and many has been filed. Unlike the PCT and the Hague filing, a pre-existing US trademark application registration is necessary before proceeding with a Madrid application. The US application is called the base application. If the Madrid trademark application meets the WIPO formalities, an international trademark certificate of registration is issued. Each designated country then examines the application and decides whether to grant protection. The Madrid International Trademark Registration is then only effective in those designated countries that have agreed to grant protection. As mentioned before, there's no deadline to foreign file a trademark. So additional member countries can be subsequently designated in the Madrid International Trademark Application or registration anytime after the initial filing. You can even designate countries that become members of the Madrid Protocol later on. An important note is that the Madrid International Trademark Registration is dependent on the base application for a period of 5 years. That is, if the base application fails or becomes invalid, then the international registration along with all the extensions will also fail. This is a very important notes for Madrid trademark, because that's slightly different, slightly different from utility and design for protection under the PCT and the Hague design, where they are not tied into any piece application, and they are all individually, separately stand on its own for each country that decide to grant the rights. So now we're going to shift our focus to China. As pointed out, China is a member of only 4 out of the 5 international treaties and agreements that I mentioned before. China is a member of the PCT, the Paris Convention, the Madrid Protocol, and the Berne Convention. Missing here is a Hague Agreement for the design patent application. Although we understand there are talks regarding of China joining the Hague International Agreement also. So when filing a design patent in China, while you can claim priority to the US application under the Paris Convention, it must be filed directly in China and not through any white boat resources. So the type of IP protection that I'm going to be talking about for China will be essentially similar to the US. Next slide. IP protection that are available in China includes utility invention patent, a utility model patent, design patent, trademark, and copyrights. So compared to US, we don't have the utility model patent. China has it, and a few other foreign countries do have utility model patent. So what is it? We'll talk about that briefly and compare it with the utility invention patent. Next slide. A China utility patent is similar to a US utility patent, which are substantially examined. On the other hand, a utility model in China does not get substantively examined, and the examiner does not do a full prior art search and only gets reviewed for formality purposes. So it's a lot easier to get and a lot quicker to secure. Where it takes 3 to 5 years to get a utility invention patent, it only takes 1 to 1.5 years to secure a China utility model patent. The terms of protection is also shorter. It is only 10 years for a utility model patent and 20 years for utility invention patent. So why do I want to point out the China utility model patent? It is the speed of protection that is most important here. Instead of waiting for 3 to 5 years, you can secure protection in less than 1.5 years. Note that you don't really have to choose one or the other. In fact, you can apply for both invention and utility model patents on the same invention. That way, you can secure prompt protection of your utility model patent upon issuance. However, if and when you can secure the utility invention patent down the road, then you must abandon the utility model patent. And if you end up not able to secure a utility model patent, at least you'll have that protection. If you end up not able to secure utility invention patent, then you can at least have the utility model patent as a backup protection of your invention. Examples of, just go back to the slide, please. Example of what a utility invention patent and a utility model patent looks like are shown there. They really have the same format. They all have claims, abstracts, specification drawings. It's really the title that are different, which says at the top of that each page over there. Okay, so now I'm going to talk about the remaining IP protection available in China, and I will briefly highlight the differences from the US. So unlike in the US, a China design patent does not get substantively examined. So it takes a lot quicker, it's a lot quicker to secure, and they only review it for formality purposes. So once it meets the formality, it will grant the design patent rights. Typically, it takes less than 1 year to secure in China. In the US, it can take any time from 1 to 2 years. The term of protection is only 10 years versus 15 years for a US design patent. There is also an annual fee required to maintain a Chinese design patent, whereas in the US, there is no maintenance fee required at all. Next, I mentioned China trademark. And the most important thing to note is that, should just go back to the slide before. I didn't point out the example of what is the design patent certificate that's shown on the right there. It's really I don't really have anything to say particularly, but I just want to get everybody to take a look at it, and so you can see the difference of what each certificate look like. Okay, now we can go to China trademark. So for China trademark, like I mentioned before, China is a first to file country. So what it means is that an infringer or squatter can easily hijack a brand owner's trademark and register it and prevent a legitimate brand owner from securing trademark protection. This is very common in China. While there are recourses for brand owner to try to get the trademark back, it is often a costly uphill battle and it's not guaranteed that you'll win. It is certainly much cheaper to file early than to having to fight for the trademark later. Another difference is unlike the US, where actual use of the mark is required to secure a trademark registration, you can secure a China trademark registration without use at all. This, along with the first to file system, exacerbate the infringer or squatter problem that many have faced in China. However, a trademark not put into use can be subject to non-use cancellation as long as it hasn't been used for 3 years. Any interested party can seek that non-use cancellation. However, you have to wait till 3 years after it has been registered in order to pursue that recourse. Examiners of China trademark application is also a little different from the US. While US considers similarity of goods, China strictly considers the classification system by subclass. So for example here, if Burberry has a registration for Burberry for a jacket in subclass 2501, a third party can register the same mark Burberry for a cycling jacket because it falls under subclass 2503. This would not be allowed in the US examination system. So when filing a trademark, we need to take a defensive filing strategy and consider all relevant subclasses and protect them at the onset. And similar to the US, it takes about 1 to 2 years to secure a China trademark registration also. And on the right of this is a sample of a China trademark registration certificate for the wet brush, the logo, which you can see here on the right. Finally, I want to briefly mention the China copyright. Similar to US, China has a registration system for copyright, and it is very quick to secure. It takes very short time, less than a year, and typically as little as 1 to 3 months, you can secure a copyright registration in China. Whereas in the US, it can take us about 6 to 9 months, sometimes shorter, sometimes longer, but it generally takes a little longer in the US to secure copyright registration. So for a trademark that includes a design element such as the logo or even a stylized English mark, it is worthwhile to even try to secure a copyright registration for the design of a logo. Registered copyright can be used against a trademark infringer for any goods and services and not subject to the subclass issue that we discussed before. In fact, the certificate I show here at the bottom of the screen on the China copyright registration is for the wet brush logo, which was covered by the China trademark registration shown on the previous slide. So it is important to consider all different coverage in China. Copyright is certainly something that is worth investigating based on the cost and the coverage that it can protect you on your brands. In fact, we have also successfully pursued trademark registrant who try to register the wet brush trademark with the copyright registration that we have, because the copyright registration predates their use and filing of additional China trademark for the same or similar logo. So finally, as the takeaway at the end, I just want to remind everyone there's really no such thing as an international patent or international trademark. And you really need to get protection on a country-to-country basis. Even the various international treaties and agreements that are available do not cover all the countries in the world. And it's somewhat impossible to cover even all those countries within the provided by international treaties and international agreements, because it's very costly to pursue every single one of those countries that are members. And second, to file sooner than later. It is very important. You snooze, you lose. And that's especially the case in China, and especially the case for patent where you have statutory deadlines. And for trademark, first to file country like China and any other first to file countries. Finally, I want to just point out that we do have contacts and with IP professionals throughout the world that will assist us in any foreign filing rights. And this is a network of foreign professionals we've handled and dealt with in the past. If you have any questions, feel free to email me, reach out, and we'll be happy to assist you. And wanted to remind everybody, thank you for joining the webinar today. And don't forget to join the last of our series of the webinar that's going to be held next week. Thank you.